5 seconds to go. Start. Apart that there was no fault on the part of the trial court or the investigating agency, it is also noteworthy that, contrary to even a trace of want of mental capacity of the appellant at the time of commission of the crimes in question, the manner of commission, with strangulation of the children one by one, throwing of their dead bodies into the canal, appellant himself swimming in the canal and coming out, and immediately thereafter, stating before several persons that the children had accidentally slipped into the canal so as to project it as a case of accidental drowning, if at all, show an alert and calculative mind, which had worked with specific intent to cause the death of the children and to cause disappearance of evidence by throwing dead bodies into the canal, and thereafter, to mislead by giving a false narrative. By no logic and by no measure of assessment, the appellant, who is found to have carried all the aforesaid misdeeds, could be said to be a person of unsound mind. Thus, we are clearly of the view that the appellant was neither suffering from any medically determined mental illness, nor could be said to be a person under a legal disability of unsound mind. Hence, neither section 84 IPC applies to the present case, nor section 329 CRPC would come to the rescue of the appellant. The suggestions about treatment of the appellant for his abnormal behavior in jail also does not take his case any further. As noticed, there is nothing on the court to find that the appellant was a person of unsound mind at the time of commission of crime, or was a person of unsound mind when tried in this case. Post-conviction behavior is hardly of any relevance so far as present appeal is concerned. In fact, his post-conviction abnormalities, as dealt with in year 2013, that is, nearly 2 years after the impugned judgment of the trial court, cannot even remotely be correlated with the relevant questions arising for the purpose of present appeal. Even in that regard, the report of the medical officer independent charge, Central Jail number 5, Tihad, New Delhi, dated 22nd July 2013, states that the appellant was admitted to psychiatry ward from 7th January 2013 to 4th March 2013 for complaints of abnormal behavior, but, he improved following treatment, and at the time of issuance of certificate, his general condition was satisfactory, and his mental status examination did not reveal any gross psychopathology. Hence, viewed from any angle, the contention urged on behalf of appellant, as to be given the benefit of the provisions meant for a person of unsound mind, cannot be accepted. The said provisions do not inure to the benefit of the appellant from any standpoint. We may in the passing also observe that in the given set of facts and circumstances, even when the appellant was shown to be a person taken to excessive consumption of alcohol, there is nothing on record to show if he did the offending acts in a state of intoxication so as to give rise to a doubt about intention with reference to the principles underlying section 86 IPC.